Massachusetts is a fortress of left-leaning progressivists and gun control, but there's a legal storm brewing that might tear down its walls. There's this one lawsuit that could very well topple handgun bans not just in Massachusetts, but across the entire country. In this video, we'll talk about a case called Granata versus Campbell, and why it could force even the most anti-gun states to give up their efforts to block your right to own the handgun of your choice. Massachusetts currently enforces strict rules through something known as the Approved Firearms Roster and the Attorney General's handgun sales regulations, effectively placing thousands of common, high-quality firearms off-limits to ordinary citizens. This situation has prompted many of us to demand an answer. If these are truly about safety, why do they prohibit so many proven defensive tools used by law-abiding folks everywhere else? It feels less like a measure for public protection and more like a scheme to keep your selection limited. Granata versus Campbell is now in federal court, challenging these regulations head-on under the Second Amendment and the Supreme Court's recent Bruin ruling. The prospect is so huge that if Massachusetts loses, other states with similar laws, like California, New York, and New Jersey, may have to back off from their own rosters and heavy-handed mandates. Gun control advocates know this could set off a domino effect. By the end of this video, you'll see why I believe we're on the verge of a seismic shift in the fight for handgun freedom. Massachusetts has never come out and said, "We're banning all handguns." Instead, it uses a two-part system to indirectly suppress most firearms that people want to buy. First, there's the so-called Approved Firearms Roster, a curated list of handguns that Massachusetts deems acceptable for sale. Second, there are the Attorney General's handgun sales regulations, which introduce additional hurdles that make it incredibly difficult for modern pistols to be cleared for distribution. The roster requires each handgun model to pass a battery of tests, including certain drop tests and safety feature checks, before it's allowed to be sold. On paper, that might sound reasonable if you assume it's a genuine public safety measure. However, in reality, many of today's top options, guns that have flawless track records in law enforcement and the civilian market, never appear on the list, while older, discontinued, or questionable models do. It becomes very clear that this system is more about restricting consumer choice than genuinely providing safe product selections. Meanwhile, the Attorney General's regulations add their own demands. These rules outline material composition requirements, specifying that certain metal densities and melting points are mandatory, which can exclude more affordable firearms. They also demand extra mechanical features, such as magazine disconnects or loaded chamber indicators. Sometimes these features interfere with legitimate defensive use. The regulations also contain instructions on how retailers must label, store, and transfer these firearms. They might call it consumer protection, but it's far beyond what many other states require. All of it, combined, creates a behind-the-scenes ban that Massachusetts officials can deny is a ban at all. For years, Massachusetts gun owners have been forced to jump through hoops or miss out on popular firearms altogether. But the case known as Granata versus Campbell takes direct aim at this entire scheme. The lawsuit argues that the roster and the Attorney General's regulations contravene the Constitution, particularly in light of the Supreme Court's guidance in both Heller, 2008, and Bruin, 2022. The fundamental principle here is that the Second Amendment protects the possession of firearms that are commonly used by law-abiding citizens for lawful purposes. The roster effectively outlaws numerous guns that people nationwide depend on for self-defense. If a certain firearm is safe enough for police departments or the broader American public, who is Massachusetts to decide it isn't acceptable within its borders? This lawsuit emphasizes that the state's approach has no historical grounding. The Bruin decision directs judges to look at how firearms were regulated at the time of the founding, or at least within the 19th century, to see if there's a comparable tradition. Massachusetts can't find anything resembling a modern, bureaucratic list that decides which handguns citizens may own and which ones they must be denied. That discrepancy is precisely what Granata versus Campbell spotlights, and the stakes couldn't be higher. Before we continue, let me ask you, do you think such rosters and regulations really have anything to do with safety? Or is it an underhanded way to keep people from exercising their rights? Let me know your thoughts in the comments section. This conversation is vital, and I'm curious where you stand on whether these restrictions serve a legitimate purpose or if they're just a sneaky ban. Now, the potential outcome of Granata versus Campbell is enormous. If this lawsuit succeeds, Massachusetts will be compelled to dismantle or drastically revise its entire system of blocking handgun sales. But the shockwaves won't stay locked within the state's borders. Other states with rosters and heavy regulations, California is a prime example, will face a fresh round of legal challenges. California's own roster includes micro-stamping requirements that no major gun company has successfully met, effectively blocking new pistol models from reaching the state's market. That approach, like Massachusetts, has been justified under the banner of safety. However, the Bruin standard doesn't allow regulators to claim safety as a catch-all reason to erase fundamental rights. You have to show that laws restricting firearms fall in line with a historical tradition, and micro-stamping or a state-approved roster is entirely modern. New Jersey, meanwhile, has considered or enacted laws reminiscent of these rosters. If Massachusetts fails to defend its approach, New Jersey and places like it will likely have to step back and reevaluate. The same goes for New York, which has already faced challenges to its post-Bruin concealed carry regime. When a single case sets a legal precedent in one circuit, or if it goes up to the Supreme Court, those decisions might force changes across the country. Defenders of these rosters will scramble to find new ways to preserve their bans, but Bruin doesn't let them rely on vague arguments about safety. They must show a true historical parallel, and no such parallel exists. The key arguments that could dismantle handgun bans nationwide are fairly straightforward. First, firearms in common use for lawful purposes are protected. Both Heller and Bruin revolve around this idea. If a handgun is widely owned in other parts of the country, or if it's a popular choice for home defense, it's not something states can ban outright. Second, if regulators claim the authority to require certain mechanical or testing standards, they must point to historical equivalents from the founding era, or at least from the 1800s. In reality, no such laws existed. People have always been free to own the common weapons of their time, which in the modern era absolutely includes typical semi-automatic handguns. Third, arguments about consumer safety don't automatically override the Second Amendment. The Constitution trumps state-level attempts to block fundamental rights. Imagine if a state said, "Cars are dangerous, so we're only approving certain older models for sale." It wouldn't hold up if it was shown to conflict with a fundamental right, if that right existed in the first place. Similarly, states can't say, "We're going to block your ability to buy firearms that are legal in the rest of the country because we decided to add random testing hurdles." Ultimately, these laws are an attempt to control what firearms the populace can acquire. They do not exist within the historical American tradition of letting citizens choose their own defensive tools. What happens if Granata wins? The approved firearms roster would essentially have to vanish or be radically watered down, because it operates on modern-day standards with no historical grounding. That means many high-quality guns, like certain Glock models or other well-known pistols that never appear on the Massachusetts roster, would be immediately eligible for sale. The same applies to brand new designs that incorporate advanced features, which the roster tends to exclude. The victory could also address the Attorney General's regulations. These rules, imposed without the same scrutiny as past legislation, limit sales through vague definitions of consumer protection. Once they're invalidated by a court decision, the entire framework might collapse. Residents who were previously blocked from owning certain firearms would get to purchase them just like anyone else in freedom-minded states. Imagine no longer being restricted to archaic or out-of-production guns, but having access to the newest, safest, and most reliable handguns on the market, just as people in the majority of the country do. That's exactly what Granata versus Campbell might achieve, especially if it's paired with the unstoppable logic of Bruin. Anti-gun politicians, however, aren't going to roll over without a fight. Historically, whenever courts strike down restrictive firearm laws, these officials try to drag their feet or invent brand new hurdles. After Bruin, some states introduced complicated application processes for concealed carry licenses, mandatory in-person training with limited class availability, or excessive fees. Massachusetts could attempt something similar if this roster-based approach is deemed unconstitutional. They could push for different licensing schemes that require multiple endorsements or specialized classes, all with the goal of draining time and money from prospective gun owners. They might also stretch out the court fights as long as possible. Sometimes they refuse to comply, hoping to buy time and test the patience of the courts. But each time a state tries one of these tricks, it risks another ruling that closes that loophole, strengthening the pro-2A cause over the long term. New York learned this lesson when it tried to sidestep Bruin, only to face more legal challenges pointing out that the state was ignoring the Supreme Court's directives. If Massachusetts does the same, it could open itself up to additional lawsuits that ultimately tear down more gun control measures. The thing is, I don't believe these states can hold out forever. Each loss in court erodes their ability to cling to bans that operate in contradiction to the Second Amendment. Granata versus Campbell fits perfectly into this trajectory. It specifically targets the notion that bureaucrats can pick and choose which firearms you're allowed to own. In America, we have the right to decide how we protect ourselves and our families. That's not a privilege that belongs to the government. We, as supporters of the Second Amendment, have always maintained that "shall not be infringed" means exactly what it says. These rosters and regulations are infringements. They might be wrapped in official language, but all they do is severely limit our choices while failing to address criminal misuse of guns. Criminals don't care whether a model is on a roster. They'll get their guns through illegal means. The only people handicapped by these rules are honest citizens looking to defend themselves. If Granata prevails, I expect a wave of litigation across the country, targeting any state that uses a roster or a similarly contrived approach. California's Unsafe Handgun Act has already been challenged multiple times. If Massachusetts goes down first, that opens the door for more favorable rulings in California and beyond. We're seeing a pattern. Once one state's restrictive system collapses, the rest start falling like dominoes. The Constitution is on our side, and the highest court in the land has laid out a clear standard in Bruin that doesn't give states much wiggle room to craft new bans under the name of safety. When the dust settles, we could be looking at a future where rosters and extra regulations are a relic, replaced by a landscape where the right to keep and bear arms is recognized more fully. Of course, there's always a chance that Massachusetts will fight tooth and nail, possibly even appealing to the Supreme Court if it loses at the circuit level. That could end up backfiring. The Supreme Court might take the case and cement an even stronger rule that prohibits any and all rosters or similar restrictions nationwide. Sometimes, states that fear a Supreme Court precedent avoid appealing. But it's Massachusetts. They've been stubborn about gun laws for a long time, so it wouldn't be surprising if they do appeal, only to lose decisively. That scenario might actually accelerate the process of invalidating such bans everywhere. If you're watching from a state that's not Massachusetts, this case still matters because the principles are universal. No matter where you live, if your local government tries to regulate firearms in a way that clearly violates your rights, the Bruin Standard is your best shield. We are witnessing a moment in history where courts are finally taking the Second Amendment at face value and applying it the way it was always meant to be applied. I'm optimistic about the outcome, but it's going to take vigilance. If a victory comes in Granata versus Campbell, watch for Massachusetts to pivot to something else. Yet that victory could spark a chain reaction that makes life easier for law-abiding Americans who just want to buy safe, modern handguns for self-defense. The only people impacted by these rosters are those who follow the law. Criminals don't follow rosters or take note of the AG's regulations. They simply get their weapons through illegal channels, leaving the rest of us stuck dealing with fewer choices and higher costs. It's high time we toss out these underhanded restrictions and let free citizens purchase the handguns they prefer. But what do you think? Comment below, and please like, share, subscribe, and click on the bell icon for more of these videos. Thanks for watching.